Ladies and gentlemen, welcome, good morning. It is a pleasure for me to introduce this webinar. It has been now a tradition for our chamber to hold every year such a webinar dedicated to IP issues. We all know that IP questions are questions companies doing business all over the world, and especially in China, are facing and are condemned to solve. It's also very good to do prevention to avoid later on problems. And this is the purpose of such a seminar. We are very happy to do this together with China IP SME Helpdesk. It's also now a tradition for our chamber to do that with this prestigious center, which is also illustrating how sometimes the European Union can support very successful centers like the IP SME Helpdesk. I will leave the focus to Alessandra Capriglia, who's the manager of the help desk based in China. She will introduce the speaker Toby Mak. She will also hold the debate and the conclusion. So Alessandra, it's yours. Please take the floor.
Good morning, everyone. Thanks a lot for the kind introduction. My name is Alessandra Capriglia, project manager of the China IP SME Helpdesk, as Mr. Dawood kindly said. So in a nutshell, the China IP SME Helpdesk is a EU-funded initiative providing free first-line advice to small and medium enterprises who are based in the European Union and the Single Market Program. We cover 4 jurisdictions of China: mainland Hong Kong, Macau, and Taiwan, each of them having their own IP system. And in the last over 15 years, we helped over 100,000 companies. Our most important service, of course, is the helpline. You can reach out to us writing to this email address. You can call us to our Beijing office. We provide a response to your inquiries free of charge within 3 working days, and of course, in a confidential way. We organize training, workshops, and webinars, and also on-site trainings like webinars like the one of today, but also we organize on-site trainings with our partner business support organizations around Europe. We cover all topics regarding IP, so either sector focus or specific IP issues, and we cover both prevention and enforcement. We can organize for you one-on-one sessions with our IP business advisor. You can have 30 minutes, even an hour with our IP advisor to talk face-to-face, although online, about your IP strategy. Again, it's free of charge and it's confidential. And I think it's the best way to get to know what you have to do before entering the Chinese market. Or if you have any issue, if you're already in China, you have any issue with IP or any question, of course, we're there to support with first-line advice. We have a variety of self-learning materials on our website. We have IP guides with focus on industries, with focus on different IP matters, and we have also fact sheets of the different jurisdictions of China, where you can find the basic information regarding IP system in those jurisdictions, including price and timing. as well as some watch out tips and best practice. You can also find case studies, so stories of SMEs that have contacted us. And so you can read their stories, how they solve their problem thanks to our support. On our website, there is also a blog where we publish articles written by our network of IP lawyers. And I want to emphasize that all our materials are developed together with our network of IP lawyers who are based in China and in Europe. These are examples of materials you can find. We have an IP fact sheet mainland China on the left side, and here you can find, for example, technology transfer to China. And of course, all these materials are free to download directly from the website. The China IP SME Helpdesk is part of this big family of the international IP SME Helpdesks. We are 6 EU-funded initiatives under the umbrella of the European Commission, and we cover, aside from China, also India, Southeast Asia, Africa, Latin America, and there is a help desk also providing general support for the European market. We publish we promote our events and publications on social media. So feel free to follow us on different types of social media, and also WeChat if you're already in China. Now, before giving the floor to our IP expert, I would like to run a little quiz, if I may, to assess how much you know about today's topic. This will allow our speaker to define the level of depth of information that he will need to cover during the presentation. So I'm going to kindly ask you to take out your phones and go to menti.com and include the code that it is shown on the slide. Or you can also scan the QR code. I want to stress out that responses are anonymous, so no personal data is stored. So we will not see your names, don't worry. We will run the quiz again also at the end of the training to make sure that you take home the most important takeaways. Let me share the quiz itself. So I hope everybody can see it. Let's start with the first question. If you don't see it, please let me know in the chat or somewhere. So when a foreign company wants to work in China, it can avoid IP to be transferred if it hires a local agent, or transfer of IP is inevitable. I usually give a little bit of time to the audience to think about it. I see the first answer is the most popular. A lot about the presentation today will be IP management when setting up either a branch in China or hiring a local agent. Okay, let's go to the next one. If my laptop allows. Okay, what is the primary purpose of licensing intellectual property in China? Is the purpose to resign from ownership of the IP entirely, or to generate revenue through royalties, or to prevent any use of the IP in the Chinese market? Okay. Right, now, promise, this is the last question. Co-ownership of patent. Is it a good strategy to apply when managing a business from Europe? Is it true or false? All right, thanks a lot for participating in our little quiz. I will stop sharing my screen, and I am very happy to introduce you to our IP expert, Toby Mak, who has been with the help desk for many years. He is one of our key experts, but I'm very happy to have him today. He's going to cover all these issues. Pay attention, and let's see if at the end of the presentation you're going to answer the same way. Please also from now, you can write down your questions in the chat. We'll be happy to answer your questions in the Q&A session. Toby, the floor is yours. We're looking forward to hearing your presentation. Enjoy the training, and we'll talk in a bit. Toby, you should unmute yourself.
Well, thank you very much for your introduction, Alessandra. I have stopped my video and I'm now sharing my screen. Give me one moment. Now you should see my screen. I will start it to be in presentation mode. Unfortunately, I have to apologize for the two black strips on the sides because seemingly I am using a ultra-wide screen and PowerPoint does not cater this. And that's why it gives you two black strips. Sorry about that. But let's start with today's training on how to avoid common IP mistakes when doing business in China. Well, a little bit introduction of myself. My name is Toby Mak. I'm a registered Chinese patent attorney working for the IP firm T & Hao IP Attorneys, which is based in Beijing. But I've been working from home in Hong Kong since 2014. And the main reason is because I am original from Hong Kong. And I have done a lot of work mainly for two IP organizations, the AIPLA, American Intellectual Property Law Association, and IPO, Intellectual Property Owners Association. And as far as I know, I'm the only Chinese patent attorney working in a Beijing Chinese patent firm who is from Hong Kong. So if you want to know me more, I'll be happy to introduce a little bit better, but I believe there is more important for me to give you the training down the road. So these are the topics that we are going to talk about. They include doing business now or involve IP and scenarios involving IP transfer to China. And then I will try to explain why things operate differently in China than the Western world. And I will talk about different kinds of transfer and some practice notes, and then give you a case that I have experienced personally, finally with some takeaway messages. So let's talk about doing business now or involve IP. When we talk about IP intellectual property, in fact, there are generally 5 kinds of intellectual property. And this slide only shows three kinds of them. They include patents, which talk about specifically how a product works. Like here is how to identify a user using the Face ID of Apple. Well, of course, we are using Apple as an example. And of course, there's an Apple trademark in the middle of it, the black apple with a button mark. And on the right-hand side is a design patent, which specifically talk about the design of the AirPod case. If I see correctly, that should be an AirPod Pro, maybe 2. So there are the 2 types of intellectual property that I have not shown in this slide, which is copyright and trade secret. Copyright could be directed to anything in printed material or even now unprinted materials, like your user manuals or your brochures or marketing brochures and so on. And trade secret generally refer to all information that is not available to the public. Unfortunately, trade secret protection is no longer available once that information becomes public. So remember all of this, and then let's move on to the next topic, which are scenarios involving IP transfer to China. I observed from the question asked by Alexandra, and I am very glad that she asked this question, that a lot of the audiences believe that they could avoid IP transfer to China if they use a local agent. Unfortunately, that is not going to happen because the first thing you need to do is to transfer the IP to that local agent. And after that, how are we supposed and how can we be sure that that local agent would not leak or transfer the IP to anyone else? In fact, once you start any business discussion in China, you have already started IP transfer to China. So let's think about if a foreign company like yours is trying to work in China. So generally, there are only three ways. One, sell or manufacture products. Maybe both. Two, research or develop new products. And three is you do investment into China. One way, there are several ways to do it. Like internally, you set up a local branch, or externally, as a lot of you just answer the question, engage local companies to act as agent. But in any event, IP will be transferred even implicitly. What do I mean? Take manufacturing your product as an example. I cannot even imagine if you do not give the information of your products to your manufacturer in China, how could they even make your product? So when you give them the information, you have already transferred your IP out. That could be patents, that could be technical information of your products, that could be know-how, that could be anything. Or even if you ask them, very simple, you ask them to print your marketing brochures for you. You have to give them the marketing brochure, otherwise how they are supposed to print it. So when you give them that brochure, you in fact transfer the intellectual property, which for that marketing brochure is concerned, your copyright, to that Chinese printer. And you have implicitly given the Chinese printer the rights to print for you. Otherwise, they have no rights to print, and how are they supposed to make the brochures for you? So that is what I meant is IP will be transferred even implicitly, even without your awareness, and even without your knowledge. That has already happened. So how things can go wrong? Well, a lot of things could go wrong in between if things are not being done properly. They could include improperly or unclearly defined subject. That happens a lot of times. That you give the information. For example, you ask a Chinese manufacturer to make a product. You give the manufacturer all the information of your product, but you have no record exactly what have been given. And as an ongoing process, they may come back to you to ask for, okay, we do not know how to make a certain part, or we do not know how that part function. You give them further information, and then down the road, it finally becomes unclear of what has been transferred. This process could happen, say, 6 months, 3 months, 2 years, something like that. And a lot of times you may unexpectedly transfer excessive IP to the receiving party. That is your Chinese agent, your Chinese manufacturer, your Chinese partner, wherever that is. And another booby trap is there is no dispute handling mechanism. And a lot of times the consequence is the receiving party, that is a Chinese company, could continue with undesirable activities during the dispute, like they could continue to sell your products, even if you want them to stop, because they are still in dispute and there's no mechanism to handle the dispute. And after the relationship has terminated, so remember, it is just a relationship. I hate to say it, but it is like a marriage. A lot of them starts with goodwill and in a very good way, but then ends badly. So at termination, and the receiving party may still hold important materials like the mode of your products or technical information of your products, or even your trademark, while they should not, and you have no way to get them back. Another issue is when the receiving party establishes new IP. How could that happen? Because your product may have some problem. For example, during manufacturing, they may tell you, hey, look, it does not work because of this, and that. And they help you to resolve these issues. And during this process, new invention may come out. And this new invention may be established by the receiving party, maybe with you, or maybe without you. So at that point, the ownership and the responsibilities, how to handle the new IP may not be clear. It may end up with the new IP patents may not be protected, or it may even act against the giving party, that is your company. The last is another issue is assume the freedom to operate after transfer. A lot of times people believe that when they have a patent, they have the rights to practice the invention. The answer is no, that is just simply wrong. You have your patent is one thing, but it doesn't mean that you have the freedom to operate, to sell the invention. Like, for example, if it requires a certification, very simple electric certification in China, and you do not have it, then you are not allowed to sell the product in China. And freedom to operate includes this kind of certification. And sometimes you may require an IP license from someone else, like, for example, if you are using other parties' technologies. And if you do not handle this properly, the Chinese company may be sued for infringement, or it may even including yourself. And you may then have to compensate them. I'm pretty sure that, well, I believe a lot of you do not want any of this to happen. So the next topic is why things operate differently in China than the Western world. When I was in Hong Kong, I also did not understand why things operate so differently. And when I was in Hong Kong before going to China in Beijing, I was practically seeing news very much like what you are seeing now, and see okay, why Chinese people sometimes behave so crazy. I can tell you all the things has a reason, and I'm now going to share with you the reasons. There are two major issues in China. One is what I call the trust issue, and the other one is the volume issue. So let's first talk about the trust issue. Is that there's a pretty low level of trust in China by the authorities, particularly to anyone, and there's a general lack of trust between any parties. And well, think about why. And let's look who is the typical liar in the Chinese system. Well, let's stop talking about that, but the consequence is, as shown in this slide, is because there's a substantial lack of trust, there's a heavy reliance on evidence recorded at authorities, or that could be verified by independent third party. That is someone who is totally unrelated to you. Most of the time, we are talking about Chinese notary. And another consequence is registered IP prevails. Intellectual property, sometimes in some other jurisdictions, could be protected without registration. China also provides such so-called unregistered IP, but if you try to rely on that, you will find that it becomes a very painful process. A lot of times, you spend a lot of money try to prove the ownership of this unregistered IP, and you are still going nowhere in China. And that is why in China, it is essential for you to register your IP, even including patent, trademark, copyright, even copyright, designs, and like plant breed rights and so on. Anything that could be registered, you better go for registration. Otherwise, please assume you have no protection in China for that particular kind of intellectual property. And anything not in writing will be ignored. What do I mean by that? There was once a case, in fact, that's Apple, that they have someone in China sign a contract to assign them the iPad trademark, but Apple screw up because they put down the wrong trademark owner, and that is something already done in writing. And they come back and ask for correction of it, and the other party said, sorry, we are not going to correct it because you asked us wrong in the first place. So remember, anything not in writing will be ignored. Will be ignored by who? Will be ignored by the authorities, will be ignored by the courts, and so on. And another thing is electronic evidence. For example, like emails, which could be amended, generally would not be accepted by the authorities. unless the electronic evidence could be proven to be not amenable. What are those electronic evidence that are not amenable, that could not be amended? They include, a lot of times, is WeChat records, which are instant chat records. And if you look into those instant chat apps, there's one characteristic, is that you can only delete the messages after you send them out, but you cannot change them after you send out those messages. As I said, what have been signed have been signed. If you sign the wrong document and if you want to change it later and the other side refuses, done deal. And that is why proper documentation for tech transfer is vital. And it is always preferred to have witness and authorization, because then it could be proven to the authorities that later actually that has happened. And the other one is a so-called volume problem. Before I went to Beijing, I have no idea how big the volume we are talking about. And since most of you are in Belgium, you have no idea the volume problem we are talking about. But I'll just give you some numbers. First is the number of patent applications that require substantive examination in China. Since 2015, every year, there has been over 1 million such applications filed. And how many examiners we are talking about? According to last year's announcement from the Chinese Patent Office, the CNIPA, we have about 16,000 patent examiners. You do the math and you will see how many new cases they receive on average. And how many patent attorneys are we talking about? According to my knowledge, there are about 25,000. You do the math, it's just not right. And I can tell you there's not a volume that work could be done properly. And another example is the number of cases filed in just one court, the Beijing IP court. According to my knowledge, every year they now receive about 3,000 cases, and they have somewhere around, should be now about 70, 80 judges. Unfortunately, each case, most if not all of them, require 3 judges. And that is why they are facing such a high volume of work. And that is why a lot of times they rely on you to prove for them that the evidence you submit is correct and cannot be challenged. And that is why a lot of times you find the evidence that you try to use in cases in Europe, they suddenly got not accepted in China. It's because of this volume problem a lot of times. And of course, when the trust problem combined with the volume problem, it makes things operate very differently in China. And that is, if you forget anything that I talked about today, please remember one thing, is registered IP prevails. So let's now spend some time to talk about different kinds of transfer and practice notes. So generally, there is only 2 kinds of transfer. They include assignment, which is if you're talking about what it is basically selling your IP, and you just sell it for good. You assign the IP, and that's done. And the second type is licensing. It is a lease, and it is usually for a certain period of time, but indefinitely if you do not specify in the license, and you transfer the IP in and out of China. Let's talk about all these scenarios. For assignment in China, prompt recordal is highly recommended. Otherwise, the assignee's part rights to litigate may be affected, and if the assigner has dissolved or deceased, subsequent recordal can become very difficult, if at all possible. I'm now working on one case that it is a big US company. They bought a patent from another US company that has a Chinese branch. And after they bought the patent, they did not register the change. And after, if I remember correctly, 6 years, they have an opportunity to sell the Chinese patent. And they then come to me and say, okay, let's now record ourselves as the correct patentee. And then I ask them, okay, where's the original Chinese company now? Oh, they have already dissolved 4 years ago. Thank you very much for letting me know, but I think we are done now, because I have no way to to record the assignment for you because the assigner has already dissolved, and according to them, they could not find the representative of the original assigner. And to be fair, I would not be surprised if the company representative of the assigner, original Chinese company, if it has disappeared due to whatever reason. And that is why prompt recordal is important, because in this particular case, the US company could not sell their patents. And according to my knowledge, it is quite a big sum of money. And co-ownership of patent is never ever recommended, particularly in China, because unless otherwise specified, all co-owners can practice and license the patent without others' consent. What does that mean? That is, you could see suddenly your partner patentee could license your patent to your competitor, and that is something you do not want. And another problem is during litigation, because today you may say that the interest of the two patentees may be aligned, may be heading to the same direction. But who knows, 5 years later, when you start litigating your patents, whether your interest is aligned, and if one of them said, no, I do not want to sue, then you're stuck. And one typical issue that a lot of my clients run into is when they engage Chinese manufacturers, they find they produce excess products, so-called overruns, and they find such products then leak into the market without their consent, and a lot of them are not happy with that. But to be fair, if you engage a Chinese manufacturer, they will always make excessive products and they will always make overruns. Why? Because they have to prepare for the scenario that some of the products may not work properly. You may come back to them and ask for replacement and whatever, and so on and so forth. And some of them may be damaged during shipment. That's another example. And that is why they will always make excessive products. And from that perspective, they have to find a way to recover costs for making such products. And there's a leak to the market. One way I would encourage my client to do is to consider a buyback mechanism that could avoid such from leaking into the market. And another issue for engaging Chinese manufacturers is the IP filings by the licensee that is your Chinese manufacturer. Many of them are so-called bad faith registrations, but according to my talk with these companies from time to time, in fact, a lot of them file such registrations based on the fear that they would not be paid eventually, and they try to use that as a leverage, so that you would pay them, so that the foreign clients would pay them. Another issue is, as I said, if they have any IP developments and they file for themselves, then you may find that you, as the original owner, may not be able to use these new developments, which may not be that nice, because because with developments, typically that's something good that you want, or at least the market wants. And if you are engaging a licensee, there's one thing that you have to remember is you cannot forbid the licensee to challenge the validity of your IP, but you may include these clauses that you may terminate the license upon challenge. You may increase the license fees, increase the license fees upon challenge, or request for a lump sum upon challenge to defend validity. You can have any of this or all of them if you wish. But there's one thing that you cannot do, is you cannot tell your licensee, I'm not allowing you to challenge my patent or my trademark, because that's the right to challenge. The validity is the basic rights conferred by law to anyone in the world. So let's talk about the new developments. And the new developments could arise from development during cooperation. A lot of times it could be improvements on the products, and it happens a lot of times. However, the Chinese contract law and the anti-monopoly law, again, do not allow us to prohibit technology development. And it does not allow automatic back automatic back assignment in the contract, which violates the Chinese contract law and the anti-monopoly law. So in exchange, that's something that I would ask you to consider, is to have good mechanisms for good record keeping to identify the inventors so that the ownership could be determined. Like if your company has contributed, then you have to have records showing that you have contributed, and then you can say, okay, someone from your Belgian company is the inventor, and that is why you have a share of it. If you have no records, then subject when you two argue for the ownership, then the Chinese company would say, hey, look, we have all the contribution and it seems you have nothing. That's why the new invention belongs to us. And then you have no records to prove otherwise. If the ownership distribution cannot be decided at the start of any project, which happens a lot of times, you should at least consider to have mechanisms for discussion of the ownership and costs for establishing IP. Like, for example, it can be put down that, okay, we the Belgian company, will pay for all the costs, and that's why we can have part of the ownership or a back license, and so on and so forth. Another thing to remember is for developments during the project, if you engage in the Chinese environment, is for inventions completed in China, must obtain security clearance before filing patent applications elsewhere, or otherwise, your Chinese application may become invalid even if granted, and the application should be rejected according to the Chinese patent law. And if well, hopefully we won't get into there, but if it involves national security, then it could be prosecuted. It could be a criminal offense. If the IP, or in most of the time is a patent, is completed by more than one entity, for example, A and B, then unless otherwise specified, A and B are co-owners of the invention. And if B declares giving up the patent rights and A then obtains the patent, B is entitled to practice the invention for free. And if A or B disagrees to apply for the patent, then the remaining party cannot apply for patent on its own. Again, unless otherwise specified, when selling the new IP, there's a default first right of refusal according to the current order, to the inventors, the client of contract research, and the co-owner of the invention. And for contract research, unless otherwise specified, the entity completing the invention owns the patent application rights. Well, there's one good thing is the client of the contract research is entitled to practice the invention for free. If you do not want anything that I just said in this slide and the previous slide, please specify that in your licensing contract or your collaboration contract. For a patent license, the Chinese contract law requires the licensor to provide information, guidance, and assistance to the licensee to practice the invention. Well, there's a question is, does it include trade secret? But to be fair, if you engage into such an agreement, then and you just give something to the licensee, and the licensee could not even work the invention. So from the perspective, that's not a deal at all. Well, the good thing is unless you specify otherwise, the licensee is not allowed to sub-license without the licensor's consent. Another topic that we need to be aware of is the transfer of IP in and out of China. In fact, there is administrative regulations on export and import of technologies, which divide technologies into 3 categories. They are the forbidden technologies, which are not allowed to be transferred in and out of China, restricted technologies that requires specific approval from the State Council, and free technologies, which include all other technologies that do not belong to the forbidden technologies and the restricted technologies. There's a list of these technologies that I can share with you if you are interested. But a lot of times, if you are engaged in the international business, unless you are going into areas like encryption or AI, then a lot of times, or special methodologies, then it is not a concern. But if you are in a business that a lot of times require government approvals to do something, then you should be careful about this. Well, let's spend some time to talk about specific case that I have personal experience with. It is not very difficult. It is a UK inventor who invented the chair, and the inventor then want to make good money out of it, but that's an individual inventor only. And the inventor then needs to find someone to make the chair for him and then sell in the UK and in Europe. The inventor then engaged a Dutch company, which the Dutch company then engaged and subcontract to a Chinese manufacturer, mainly because of lower cost to make the chair. Well, the UK inventor is not too naive. The inventor filed a UK application, but the inventor abandoned the application prior to publication, before the UK application is published, and did not file in anywhere, including China, within the necessary time period. So what happened next? Then the relationship with the Dutch company turned sour, went bad. As I said, it's just a marriage. It could end up bad. Then the UK inventor found a French company to continue the project. But when the French company wants to start with the UK inventor again, they find out that the Chinese manufacturer has registered design and utility model for the chair in China. So what's the consequence? Everything puts on hold until the Chinese utility model and the design patents are resolved. So what can the UK inventor do? Well, the UK inventor can try to invalidate the Chinese design and the Chinese utility model. However, it is unlikely to be successful, as the invention was not publicly disclosed before these applications, this Chinese design and utility model were filed. Remember, the UK inventor has abandoned his UK application before publication. Sadly, the UK inventor can try to claim to be the correct owner of the Chinese design and utility model. But again, it could be difficult because the Chinese designs and utility model were filed in the name of the Chinese manufacturer. From a Chinese patent office perspective, okay, you suddenly jump in to tell me that actually it is owned by you. Well, give me the evidence, show me. What evidence can the UK inventor has? The UK inventor has no direct communication with the Chinese manufacturer, and all the communication between the Dutch company and the Chinese manufacturer is not accessible to the UK inventor anymore, because remember, the relationship between the UK inventor and the Dutch company is no longer good. So this is another difficult path. However, the Chinese design and the utility model would not be a problem at all if the UK inventor filed a patent application in China. Unfortunately, he did not do it. So let's now go to the last topic, which are some takeaway messages. Sorry for the siren, because seemingly there is an ambulance going by. Sorry about that. Some takeaway messages. First, do not implicitly transfer your IP, because once you start any business talk in China, in fact, you are starting transferring your IP without your knowledge. And once you do it, there's practically no control. That's why you have to please have this awareness. I'm not asking you to tell the other parties to sign a contract every time when you talk about anything. It does not work for most businesses. But please have this awareness. Once you are aware that you are talking to the other party, all the things I talk about today is not only applicable in China, but applicable for you to do business in anywhere of the world. Once you talk with someone, please be aware that you may be transferring your IP to the other party. And with this awareness, then you have to think about, okay, which is the important information that I need to be more careful. when I'm talking about it. And before you talk about that particular important piece of information, please then at least talk to your IP advisor, talk to a lawyer, talk to a patent attorney, whoever, about, okay, I'm going to give this away. What should I do? And when you involve a subcontractor, remember the case of the UK inventor. When you have a Dutch company in between, you have to pay extra caution about that. Again, if you forget anything that I talk about today, please remember one thing: register your intellectual property before having any direct or indirect business discussion in China. Because if you do not register your IP, then someone will do it against you. It could be your Chinese partner, it could be whoever in China who knows about you from the internet. And registering IP in China, it does not only serve offensive, that is, it does not only allows you to sue someone for infringement, but also have the defensive purpose for proving your ownership, at least. So that's the end of my talk, and I'll be happy to answer any questions that you may have. Let me stop.
Thanks a lot, Toby, for the presentation. I think it was very useful for everyone. Now I am going to bother everyone again with the quiz. Let's see if everyone has listened carefully and is able to answer the questions this time correctly. Then, of course, we'll move to a Q&A session. So when a foreign company wants to work in China, it can avoid it can avoid IP transfer if it hires a local agent, or transfer IP is inevitable. Yeah, we see that this time everybody is getting it right. Let's continue. What is the primary purpose of licensing intellectual property in China? To resign from ownership, to generate revenue through royalties, or to prevent any use of IP in the Chinese market? Then we'll ask Toby to comment on the answer, maybe. And last, co-ownership of patent is a good strategy to apply when managing a business from Europe. Yeah. Okay. Thanks a lot for your patience and for participating in the quiz. I don't know, Toby, maybe you want to comment very quickly the answers to the second question. I think some people were a bit confused. Unmute yourself, please. Sorry.
Yes, you are right. It is in fact quite confusing, because licensing is something, it could be done very casually, and it could be done very specifically. What I mean by casually is that, like as I said in the talk, is when you engage a Chinese manufacturer, and you will somehow license the Chinese manufacturer to make the product for you, because otherwise you have to give the Chinese manufacturer rights to do it, because otherwise the Chinese manufacturer is not supposed to make the product at all. And that is why implicitly you already have the license. And such implicit license, in fact, happens a lot of times. Like, for example, if you even want to sell your handbag, a specific design handbag, to China, and you engage a local agent, you have a trademark on the back, you have the designs on the back, then you have to allow your local agent to use your trademark and use the designs. Otherwise, how your local agent is supposed to have the right to sell for you? These are all the implicit license that I'm talking about. And it is generally about making money for you, generating revenue. It may not be directly coming from the license fees, but the revenue is generated from the business activities when you engage with that local party. It could be in China, it could be in Latin America, it could be in Southeast Asia, it could be India. That's the general idea. And that is what I meant by when you engage in such activities, please be aware that you are implicitly licensing your IP away. And that is something you do not want. That is a time when you want to have a written license. Okay, this is what I'm going to do with you. This license, you are my local agent. I'm allowing you to use my trademark for selling this product. You may specify how long it is. You may specify how this license contract could be terminated. You may specify the performance of your agent to be reviewed. If the performance of your agent is not satisfactory, you may give them some compensation. Give them some punishment, or you may terminate the license, whatever. But if you do not have this in mind, and you just you go and do it, they will just grab it away. They will just walk away with your intellectual property, your designs, your trademark, your patents, your know-how, your trade secret, your copyright. And that is not something that you want. That is not something any business wants.
Yes, thanks a lot, Toby. Yes, I think this is an important lesson. I think a lot of companies overlook those aspects and think that as like a simple agreement is enough, or sometimes the devil is in the details. Let's say like this. And we have a question from the audience that I would like to ask you. It says, what share of the authorized capital of a joint venture in China can IP comprise?
Sorry, can you repeat the question? Because I'm just not sure whether I hear it right.
Okay, so what share of the authorized capital of a joint venture in China can intellectual property comprise?
Well, it is a business discussion. For some structure, the IP could be the whole investment from one side that is going to put in, and how the share is going to distribute. That's another question, and it depends on the specific industries, because in some specific industries like the car manufacturing, the joint venture of a foreign company that formed with a Chinese companies is required that the foreign companies can have only at most 49%. But in most other industries, there is no such restriction. And with the share, then, well, it is up to the two parties to talk about how much the IP is going to worth for the shares. The typical model is, well, you have the intellectual property, and you said, okay, it is going to worth X amount of money, let's say 30 million RMB, and then, well, based on that 30 million, then that's how the share is going to be calculated. For example, of course, you said 30 million, the other side may say, hey, I disagree. It looks to me that it worth only 3 million. Then it has a lot of back and forth going around.
I see. Thanks for your answer. I do have a question actually for you, going back to the UK case study. In the meantime, if anyone has any other question, please feel free to write in the chat. What would you have advised the UK company to do in terms of patent and utility model? Is both of them a good strategy to apply for, or what's the approach towards utility model and patent? I think this is also creating a lot of confusion in SMEs, as in China, I think it works a little bit different. Sure.
Utility model could be viewed as a subset of patents in China. It is actually the same as the typical patents that we talk about. but with several characteristics. The first one is the subject matter is restrictive. Utility models only could protect products with new shape and or structural features. That's one thing. So if your invention is a method or your invention is a chemical, then by definition, utility model is not suitable to you. The second distinction is utility model generally does not go through what we call substantive examination. Substantive examination for patents includes several steps, but in general, they include the steps of the examiner reads the patent specification, then the examiner do a patent search to find prior references that are relevant to your application. Then based on those references, the examiner read through them and then tell, okay, whether your invention is new or inventive. If not, the examiner would write an examination report telling you that, okay, I'm not granting you a patent because I find this reference makes your invention not new or not novel, or your application has other defects and so on. And until you can satisfy the examiner, you do not get a patent granted. But if you satisfy the examiner, you get a patent granted. So the steps that I just talked about is called substantive examination. Utility model generally does not go through substantive examination. As long as it looks okay. How do you not look okay when you file a utility model? You include what we call claims for methods. You include in the utility model that a lot of characteristics that are not related to the shape and or structure of the product. Then it may cause a problem. But otherwise, they just, okay, it looks okay, then they get it granted. But now the CNIPA include a so-called apparently not inventive tests. I'm not sure exactly how they do it, but it seems that they are using AI to check out claims that are apparently copied from other applications to exclude them from getting granted. But in general, if you get a utility model, you can get it quite quick. The third characteristic is the utility model has only 10 years at most, maximum term, compared to 20 years. So all in all, utility model is good for if you're having a specific product that has a relatively short commercial lifespan. But unfortunately, for utility model, seemingly the Chinese government is considering it to be less and less useful because the most recent change of the Chinese patent law, they increase the maximum term for design patents, but do not do that for utility models. So, and they have applied now quite a lot of restrictions on enforcing utility models, which makes things not, and that's the other thing. And they now process in the typical patents to have them granted more quickly, which all of this make utility models less attractive than before.
Okay, interesting. Yeah, I didn't know that there were changes in terms of that, because I think, yeah, it used to be a sort of strategy for SMEs to file both a utility model and patent so that utility models are approved a bit faster.
Yes.
Yeah. But
in general, in general, I would strongly recommend any foreign companies to file for so-called to actively obtain register trademarks and design patents. Why? Because there's a specific kind of infringement in China that actually I experience a lot of times. I'm not sure whether you have seen it. It is just a fake product. It does not work, but it looks exactly the same like yours, even bearing your trademark and your model number on it. But it just does not work. So what does that mean? That means by definition, there's no patent infringement, because patent is talking about how the product works. And because it does not work, it does not fall within the scope of your patent. And if you do not have a registered trademark, and if you do not have a design patent, there's nothing you can do in China against such fake products. While by comparison, if you have a registered trademark and a design patent, then the enforcement could be a lot more effective, because for a lot of Chinese civil servants working in, for example, like the customs or the local IP enforcement. They are not very sophisticatedly trained. But if you give them something that they can just determine by their own eyes, whether they look the same or not, they could do it. But if you ask them to determine quickly whether there is a technical patent infringement, that's not something that they could do easily. And it's just a general rule. And again, because of the volume issue, they always go for the easy case. So what I'm talking about is if you have registered trademark and if you have designs, you are giving the Chinese authorities an easy case to help them to make good, to look good in front of you.
Yeah.
Isn't that easier for them to do it?
Interesting. Thanks, Toby. We do have another question. This company is wondering if there is anything else other than trademark registration to make sure that their IP is safe in China. And we are referring specifically to pharmaceutical products to be sold through the CBEC.
What is CBEC then?
I'm actually not sure. I can ask maybe Mr. Power-Weck to specify it in the chat.
But anyway, if it is a pharmaceutical product,
cross-border e-commerce. Okay.
Okay. Well, in fact, you're going into a pretty dangerous business. Why? Because in fact, selling pharmaceutical products has quite high liability, particularly cross-border, because every country has its own so-called drug marketing approval. And if you do not do it right as the importer and as a seller, they could get you into liability status. I'm not even talking about IP at all. I'm just talking about the general business. That's something you should be careful about. And the second thing is, if it is a pharmaceutical product, naturally it does not only involve trademark, in fact, it involves patents a lot of time. It may also involve design because the bottle or the shape, or even the shape of the pills, if it is in a pill form, could have a specific shape. And it could include copyright. Why? Because you would have a product insert that is copyright material. Don't ask me how come, but I get into a case that the drug has no problem with patents, but because the generic drug, they copy and paste the exact same product insert of the original drug developer. In fact, they constitute copyright infringement. It happened. And patents direct to either the active ingredients, the formulation, the license indication of the drug, or the method of manufacturing of either the active ingredient or the drug itself. So we could be talking about patents, designs. Most of the time it's trademark and patents. Copyright also for the product insert. In some rare cases, maybe design. All of this have to be registered, as I said, because if you don't, in fact, you have no protection. I have a lot of clients telling me, I have registered my patents in Europe, but we found infringement in China. What can you do, Toby? Okay, have you registered the equivalent patents in China? No, we have never done it. Then you have no rights in China. What am I supposed to do for you? In fact, particularly for patents, because patents will be published during the application process. A lot of times people are not aware of one thing is if they apply for patents in the rest of the world, but not in one particular country, they are not aware of what is the equivalence. It is equivalent of you giving a free license to anyone in that country that you do not file, a free license to practice your invention. And by all means, don't file in China. And while you have filed in Europe or the US, and then I will thank for and on behalf of all Chinese people for your free license to practice your invention in China. Thank you very much. If you do not want it, then file in China. As simple as that. And there are a lot of deadlines to observe in order to obtain your patent rights properly. And that's something you need to talk to your patent attorney. I probably is not the right person for you to talk to because I'm too remote from you. But you will always be able to find European patent attorneys in your own jurisdiction.
Yeah, I think we never stop stressing how important, like the concept of the first to file system. The fact that you own a patent in Europe doesn't mean that. So it doesn't matter who's the original owner of or creator of innovation or product. What matters is who registers the IP at the end of the day.
Yes, correct. And that is why you find. Have you? I'm pretty sure you have heard about the Michael Jordan case in China.
Yeah.
That they registered the flying man, and I can tell you what happened is Nike and Michael Jordan just ignore all of this for 6 years.
Mm.
They knew, but they just did nothing. And after the Chinese business grows so big, get the attention, they try to knock it out. They had a hard fight because they did not register anything.
Yeah, there are a couple of those cases also of like important brands. I think also Apple had a similar situation. And yeah, the importance of layer your IP so you can protect your product, your innovation through different kinds of IP, not only trademark or not only patent. We have a few more questions. I think you addressed this a little bit. So for enforcement of Chinese utility models, is that any different from enforcing patents?
Yes, there's one major difference. Is that in order for you to enforce a utility model of yours, you need to first obtain a so-called patentability evaluation report issued by the CNIPA, the Chinese Patent Office. This report is very much similar to an examination report of a patent during application process. The difference is this report is final. If the report says your utility model is not good due to whatever reasons, not novel, not inventive, not clear, whatever, you're stuck. But if the report says, oh, it is okay, then the authorities, like a court, would accept your case. Otherwise, the court would say, why I should accept your case? The report says your utility model is no good. That's one major difference. Otherwise, the remaining processes are the same, and the requirements, like for example, to constitute infringement, they are exactly the same.
Yeah. Thanks. And then Mr. Pawełek actually had a follow-up question regarding the question on the pharmaceutical products. Would anything be different for functional foods or food supplements?
Oh, okay. Then they are not drugs by definition.
Yeah.
They are not pharmaceuticals. So that is an open area, but again, it is the same thing. You can have patents. Most of the time, you have trademarks. That's the number one thing that you should be concerned of. And then you have patents. And again, you may have designs and you may have copyrights. But yet again, before that, the first thing I would like to raise your attention is be careful of the liabilities that come along. If people eat your products and then get into whatever trouble, go to the hospital, it'll be on you and on your distributor in China. I've seen this a lot of times. And who knows what happened in between. I mean, you may be selling good products in China, but you may have two things: is when it reaches China, somehow the quality deteriorates. Your product quality deteriorate. That's one thing. Another thing is you're facing, as I described, fake products that looks exactly like yours, which are not from you, I know, but I mean, from the customer's perspective, how could they distinguish?
Yes, of course. So, well, The general advice is register your IP beforehand, even before attending a trade fair in China. I think a lot of companies make this mistake. And also be supported by either by us for the first recommendation and advice, but be advised by a lawyer. And there are a lot of factors to consider when developing an IP strategy to China. It cannot be overlooked. It's important to protect your assets because you gain a competitive advantage in the market. Otherwise, you have to abandon your market, your China goals. I think we do have another question. So I hope we have still some time. Do you recommend to file a Chinese utility model parallel to a EU priority patent application?
Again, it depends on the product.
Mm-hmm.
If it's not a physical product, then it is not suitable at all. But in general, I do not recommend people to go after utility model, because right now, if you want a patent to be granted in China quickly with proper substantive examination, it could be done. I have ways to do it. Specifically, is to use the so-called patent prosecution highway. Of course, it may not be granted as quickly as a utility model, but it could get granted in 12, 18 months if you are lucky, with a proper strategy established, but it has to be established in the very beginning. The way to do it is first to obtain a quick grant in a country that can give you quick grant with proper substantive examination. Most of the time, my recommendation is the United Kingdom. Mm-hmm. Get a GB patent, then file a patent application in China using the GB patent as a basis of the PPH request, patent prosecution highway request. Then you will find, well, in my case, at least 60% of the time, then you just get granted without major issues. And it can be granted in, say, 12, if we do all the things fast, all the things very quickly in the very beginning, it could be granted in 12 months, 18 months, something like that.
Well, thanks a lot, Toby. It was very interesting, and also thanks for responding to all the questions from the audience.
Before we go, can I also talk about one thing?
Of course, yes, go ahead.
It's about IP budgeting.
Okay.
It costs money to either establish your IP, to monitor whether there's infringement, and to enforce your IP. All of this costs money. They do not come for free. No government will come up and say, oh, I'm going to protect your intellectual property free of charge. No government does it, because at the end of the day, it is your property. It's like your house. I mean, you ask the government to pay for all the conservation costs, they're not going to do it. So you have to prepare a budget for it. Exactly how much are we talking about? I have asked different companies for their comments. It depends on the products and how sophisticated the technology are we talking about. But in general, we are talking about somewhere between 5 to 10% of the revenue. And we are talking about protection period, maybe for somewhat from 5 to 15 years. It's not something that would happen for only 2-3 years. I have a client that sold their products like 10 years ago in the US. They now come to China, and they find infringement in China. Ask me, okay, how much are we talking about to enforce? I tell them, well, look at your revenue. Say it is somewhere between 5 to 8% for you just to enforce.
True, because registration is something that you have to monitor.
You have to monitor. You have to collect all the evidence. You have to establish the infringement opinion. You have to file your court case. You have to file a case with the local authorities, so on and so forth. All of this costs money. You expect the investigator to work for free for you?
Well, yeah, but it's still, even if it's, let's say it's more like an investment, because if you don't do all these things, then, well, you lose even more money.
So
If
it is, yeah, it's a tricky, it's a chicken and egg problem. The way I usually describe to people is consider intellectual property is your travel insurance.
You're sorry?
Your travel insurance. There are
Travel insurance.
There are a lot of similarities between the two. Of course, they're not the same. But
Yeah.
the strange thing is, in fact, if you need to use your intellectual property to protect your business, my first thing I'm going to say to you is congratulations. Why? Because I have never seen unsuccessful products for the intellectual property to be infringed. That means your product is successful in the first place. That you have to consider that is a happy problem. Because you are not dealing, oh, I have too many stock, I don't even know how to get them away.
Yeah. Thanks, Toby. Okay, I think we are running out of time. Thanks a lot again for your availability. Thanks to participants, and thanks, of course, the Chamber for the Belgian-Chinese Chamber of Commerce to organize this training with us. If you have any other questions, please do feel free to reach out to the help desk or to reach out to Toby's directly, Toby's email directly, as he shared, I think, on his slides. Yes, so here's some information about the Belgian-Chinese Chamber of Commerce for you to take away. And until next time then, have a nice day and good luck with your China market entry. And remember always to think about your IP strategy. Thanks a lot, and until next time. Bye, thanks, Sophie.